When does the WARN Act apply to company layoffs? Imagine planning a big change at work and wondering if you need to give employees a heads up. That's where the Worker Adjustment and Retraining Notification Act comes into play. This law sets rules for certain layoffs and plant closures to protect workers and communities. Knowing when it applies can save employers from legal trouble and help employees prepare for changes ahead. The WARN Act only covers employers with a certain number of workers. At the federal level, companies with 100 or more full-time employees must follow its rules. But some states, like California, have their own laws. California's law applies to companies with 75 or more full-time or part-time workers during the past year. When counting employees, employers include workers from all locations, not just the site where layoffs happen. Federal law usually counts only full-time employees, but California includes part-time workers too. The law kicks in when specific actions happen. If a company closes a plant or facility, and at least 50 workers are affected, the WARN Act requires a 60-day notice. A plant closure means shutting down a location either temporarily or permanently, impacting at least 50 employees at that site. For mass layoffs, the law applies if 500 or more workers are laid off within 30 days at one location. It also covers layoffs of 50 to 499 workers if those layoffs make up at least a third of the total workforce at that site. If a company closes an entire building or stops a major part of operations, and at least 50 workers are laid off, the law applies too. Temporary layoffs are also covered if they meet certain conditions. If a temporary layoff turns permanent or lasts longer than 6 months, the law applies. Even if a layoff is initially temporary, if it extends beyond 6 months, the company must give notice. The law also covers situations where working hours are cut by 50% or more for 50 or more workers each month over a 6-month period. It's important to look at layoffs over a period of up to 90 days. If a company lays off smaller groups of workers within that window, the total number can add up and trigger the law. For example, if a company lays off 40 workers one day and then 30 more within 90 days, the total 50 workers are covered. The employer then needs to give a 60-day notice to all affected employees. When the WARN Act applies, employers must send written notices at least 60 days before layoffs. Notices go to employees, their representatives, local government officials, and state agencies. In California, employers must also notify local workforce development boards and city or county officials. The notice should include details like whether layoffs are permanent or temporary, the date layoffs start, and if there are any bumping rights or severance packages. The law helps workers by giving them time to find new jobs or training. Employees, whether managers, supervisors, or hourly workers, are protected. If employers don't follow the rules, they can face legal penalties. They might have to pay back wages and benefits for the missed notice period, which can be up to 60 days. Even if layoffs seem sudden or unavoidable, the law expects employers to give proper notice. In the context of employment and layoffs, understanding when the Worker Adjustment and Retraining Notification Act applies is key. Employers need to carefully evaluate their workforce changes to stay compliant. Proper planning and early legal advice can prevent costly penalties and ensure a smoother transition for everyone involved.